evidence.
Secretary,
Yes, Mr. Bowen.
Good morning, my lords, my lady. Thank you for the early break yesterday. It's given me a chance to pull together some strands and to respond to some of the questions from the bench yesterday. I was dealing at the end of my submissions yesterday with the fresh evidence application. I've already indicated that I was proposing to adopt our written submissions, which you will find in the core bundle at pages 235 and 266. And I have very little to add to those. The key point I would like to emphasise, two key points. First is that the coroner has kept open the question of whether Article 2 is engaged in this case. You will see that from her most recent decision in the core bundle at page 122, paragraph 4. So whatever your lordships decide, Dr. Langford's evidence will need to be considered by the coroner unless you have considered it yourself and decided that Article 2 is engaged. And indeed, one of the reasons why we suggest it would be artificial for you not to consider it is because it's only going to have to be considered by the coroner in any event. However, if, my lord and my lady, you take the view that you shouldn't admit it, we would ask only that you don't make any comment on Dr. Langford's evidence so that it can be considered by the coroner afresh, if I can leave it like that. In terms of the questions that arose and putting together the strands, my lords, and I will deal with this relatively shortly, but there were three questions that came from the bench. The first came from my lord, the Lord Chief Justice, as to whether the Macarazzi case, which I took you to yesterday, was an enhanced investigation case, a Jordan-type case, or related to the wider investigative duty that applies in medical negligence cases. And my lord was right to say that one doesn't find a cross-reference in Macarazzi to Jordan, but of course lots of these cases don't refer necessarily to Jordan, even though they are Article 2 cases. They as my lords know, will often refer to more recent cases which establish the same principle or applied the same principle. But there are some clues that demonstrate that this is, without any doubt, a Jordan-type investigative duty. If I could ask my lords and my lady to turn back to Macarazzi, paragraph 87, that's volume 3, the White Bundle of Authorities, at tab 57. And if one goes to 1943, the first point to make is that in the 6th line, the court refers to the duty on the authorities of their own motion to open an official probe. Now, that is a duty that only applies in the context of the enhanced investigative duty, because in a non-enhanced duty case, the duty can be discharged by making available civil proceedings that can be brought by the family. So I can make that point, my lords, by reference to Tyrrell. So if I could just ask my lord, my lady, to turn to volume 2. In fact, before you leave Macarazzi, there's one other point to make in paragraph 87, which is the cross-reference to Katz. And my lords, you can put that volume back again, and I'll just develop the points in relation to those two indicia as to why this is an Article 2 enhanced investigation case. So the concept of a duty that the state must discharge of its own motion, that is clearly made in Jordan, and the relevant passages referred to by the Lord Chief Justice in the Tyrrell case, Volume 2, tab 43, at page 1306. That's the underground 306. And the court will see, if you go back a page, paragraph 17 of the Tyrrell judgment, the link between procedural obligation and a possible breach of the substantive obligation restated by the House in gentle and arises and the procedural obligation that arises in such cases was summarised by Lord Bingham in the Middleton case by reference to paragraphs 105 and 107 of Jordan, and then the quotation from Middleton, paragraph 10, and in turn the quotation from Jordan, paragraph 105. It's the last 5 lines of the quote from paragraph 105 I just want to draw to your lordship and your ladyship's attention, where it says this: however, whatever mode is employed, the authorities must act of their own motion once the matter has come to their attention. They cannot leave to the initiative of the next of kin, either to lodge a formal complaint or to take responsibility for conduct of any investigative procedures. Now, one contrasts the position with the enhanced duty with the wider duty that arises in medical negligence cases. And the best way to do that is to go back to Lopez de Souza, volume 3, the white volume, tab 56, at paragraph 214, and specifically 220, starting at page 1864 in that volume. Page 214, paragraph 214 at 1864 is the general proposition. That is the wider investigative duty that applies in medical negligence cases, but does not bring with it all of the same Jordan requirements. In particular, and if one goes over the page to paragraph 220, it's this passage: unlike in cases concerning the lethal use of force by state agents, where the competent authorities must of their own motion initiate investigations, in cases concerning medical negligence, where the death is caused unintentionally, the state's procedural obligations may come into play upon the institution of proceedings by the deceased relatives. So that's a key indicator that that the Macarazzi case is concerned with the enhanced duty. The second key indicator is the cross-reference to Katz, paragraph 116, and that, my lord, my lady, is in the same volume. Just to go back to it, tab 54, at page 1753. And it sets out paragraph 116 on page 1753 of the bundle the requirements of the enhanced investigation. And my lords, that is exactly the same obligation that's referred to in subsequent case law on the enhanced investigation. And I'll just give you the references, I don't need to take you there. But one of them is a case called Trubnikov, T-I-U-B-N-I-K-O-V, paragraph 88, which is cited in the JL case at paragraph 74, volume 1, tab 22, page 562. And the other one is Honor Yildiz, paragraph 94, which is cited by the Court of Appeal in the Lewis case at paragraph 35, volume 1, tab 26, page 678. And my lords, if there were any need to re-emphasise the point, I showed you yesterday the case of Zidzava, which was a drugs overdose case, but that was the case which explicitly drew attention to the fact that the state killing investigative obligation also applied to deaths in custody. And I'll just give you the reference. It's paragraph 59 of Zidzava, volume 3, tab 48, page 1523. One sees it's in the last sentence of paragraph 59, top of that page. In that connection, the court points out that the obligation mentioned above is not confined to cases where it's apparent that it was caused by an agent of the state, but also includes cases of deaths in custody. So there's the explicit equation of the enhanced duty for deaths in custody to the duty in the Jordan type case of state killings. So that, I hope, answers my Lord Chief Justice's question of whether Makarati is an enhanced investigation case. The second question is it a necessary part of our case? Yesterday I made a submission that Terrell was inconsistent with Makarati. And to what extent, therefore, do we need to persuade your lordships that Terrell should be either departed from or distinguished? I think it's important to recognise that the divisional court placed considerable reliance upon Terrell, in particular at paragraphs 120 to 121. And it was central to the conclusions that it drew at paragraph 122 that there were, in detention cases, detainee cases, a distinction to be drawn between automatic enhanced duty cases and non-automatic enhanced duty cases. And the divisional court concluded that certain deaths, suicides and unlawful killings, triggered the duty, but others, such as natural cause deaths, did not. And they required an arguable breach, and that's where he then employed the same forensic technique that Lord Phillips refers to in paragraph 70 of the two stages, the initial investigation. And if the initial investigation concludes that there's an arguable breach, then the enhanced duty is triggered. And what the divisional court did was then to go on and assimilate drugs overdose cases to natural causes deaths rather than to suicides and unlawful killing cases. And therefore, one has to demonstrate first an arguable breach, and secondly, only if there's an arguable breach will the enhanced duty be triggered. My lords, I addressed you yesterday as to the reference in paragraph 70 as being in the context not of a prisoner detainee case where there's we say an automatic duty, but in the context of a prisoner, a soldier on active service where there isn't an automatic duty. That was the conclusion of the Supreme Court in Smith. And that it doesn't, in fact, provide authority for the proposition that in a detainee case, there needs to be any proof of an arguable breach before the enhanced duty is triggered. But that was the conclusion of Tyrrell. And so it may be that my lords will conclude that the only way we can demonstrate that the divisional court were wrong is if we demonstrate that Tyrrell cannot be read consistently. I'm sorry, my lord.
No,
I can hear.
There's no. We can hear you and see you perfectly, Mr. Bowen.
I'm sorry. I thought my lord had asked me a question.
No.
So do we need to overturn Tyrrell or persuade your lordships that you can depart from Tyrrell? The first answer is no. We submit that Tyrrell can be distinguished. That is to say, Tyrrell is concerned with natural causes deaths, and the ratio of the case is that in a natural causes death, there is no enhanced duty of investigation, and only if there is reason to suspect that the death arose in the context of some failure by the state to provide healthcare would there be an enhanced duty. And what we respectfully submit is that the divisional court, in assimilating drugs overdose death to natural causes deaths, was wrong. And if there is a distinction between, on the one hand, natural causes deaths, and on the other hand, suicides and unlawful killings deaths, then drugs overdose deaths should be assimilated to the suicide, unlawful killings side of the fence, and not the natural causes side of the fence. That is for these reasons. Firstly, because a drugs overdose in the case of a detainee is indistinguishable from a death by self-harm or suicide, at least at the outset of the investigation, and should be treated, therefore, as a self-harm suicide case. And that is particularly so in the case of detainees who are psychiatric patients, given that their lack of capacity is likely to make the distinction between a deliberate and an accidental death irrelevant. And the divisional court was wrong to treat Tanya and others in her case as having died as a consequence of an overdose like any other recreational drug user, which is the phrase used in paragraph 130 of the judgment. So that's the first reason for distinguishing Tyrrell, that it's not a natural causes death, and the divisional court were wrong to assimilate it to natural cause deaths. The second reason is that even if one were to treat it as an accidental death, i.e. not a suicide self-harm death, it still should not be assimilated to the natural causes side of the ledger. Because firstly, a drugs overdose is still an unnatural or violent death. And unlike a natural causes death, it will always require an inquest. And the coroner cannot discontinue an inquest on the grounds of a post-mortem report in an unnatural or violent death, just as he can't discontinue it in a death in custody or state detention case. And secondly, applying the case law of the Strasbourg court, including Zava and Makaradze, a distinction can be drawn between genuinely natural cause deaths and deaths that arise in circumstances that could give rise to state responsibility, which could be where a drugs overdose has happened. There's a further reason we respectfully submit for distinguishing Tyrrell on its facts. In that case, the coroner and the court were satisfied that the evidence showed unequivocally that the death was the result of natural causes, and that there was no reason to suppose that there had been any failure to protect his health and well-being. That's paragraph 27 of the judgment. And that case is therefore consistent with the proposition that we have put forward, that there is an enhanced investigative duty, but it is one that creates a presumption of breach, which the state can rebut. And read in that light, Tyrrell is a case where the state had produced evidence a satisfactory and convincing explanation of the death, and so it had discharged its Article 2 investigative duty. The last point we make about, well, there's two points, sorry, we make about Tyrrell, and why it's not necessary for us to persuade your lordships that it's wrong for you to be satisfied that the divisional court was wrong in this case. The first one is that when one comes to the question of does the automatic duty of investigation apply to voluntary psychiatric patients, the divisional court rejected that proposition, see paragraph 137, and concluded that voluntary psychiatric patients were not entitled to protection as a category or class. So they applied the same reasoning essentially that we said that we submitted yesterday led them to error in identifying whether an operational duty was owed in the first place. And of course, Tyrrell is not concerned with voluntary psychiatric patients. And the divisional court was also wrong, we submit, in rejecting the analysis of Mr. Justice Green in the Lex case, who of course concluded that voluntary psychiatric patients as a class were entitled to be treated to be treated as benefiting from the automatic duty of investigation. Of course, it's not them that benefit, it's their family. But so that's our starting point with Tyrrell. There are plenty of reasons that one can find the divisional court to have been wrong on the automatic duty point without deciding that Tyrrell was itself wrong. If you do not accept that submission and you consider that the divisional court's reasoning and conclusions were on all fours with Tyrrell, then it is our case that Tyrrell cannot be read consistently with the decision in Macarazzi and the later decision in Zava. So Macarazzi preceded Tyrrell, 2011. Zava, on the other hand, postdates it. It was a decision in December 2016. But Macarazzi does make clear that an enhanced Jordan-type investigation is required in relation to any death in custody due to illness or a health problem. See paragraph 72 and 87. It doesn't require a suspicious death, which was the phrase, or sorry, death in suspicious circumstances, which was the phrase used in Katz and Slimani. And of course in Tyrrell, the Court of Appeal construed that as meaning that there had to be evidence of a suspicious death. My submission yesterday, in which I maintain, is that every death in custody is suspicious because of the presumption. But if that needs to be reinforced, then Macarazzi makes clear that any death due to illness or a health problem triggers the duty. And we submit that the rationale for that is exactly the same as it is for suicides and other deaths in custody. If one goes back to what Lord Roger said in the L case at paragraph 59, and for your note, that's volume 1, tab 22, page 558. Every death in custody may be the consequence of some failure to provide adequate health care. Every apparently natural causes death. And to quote Lord Roger, given the closed nature of the prison world, without an independent investigation, you might never know. So the reasoning and rationale for the duty applies just as strongly in natural causes or apparently natural causes death. And of course, whether it is or isn't natural causes can't be decided until the end of the investigation. And the reference that the court made to the two-stage test by Lord Phillips and Smith we respectfully submit does not support the conclusion that there's a two-stage test in automatic duty cases, because that was the case where the court was only referring to non-automatic cases, and I referred you to paragraph 84 of Lord Phillips' speech.
Well, now, Mr. Bowen, as you've just indicated that you've already referred us to these passages, and
I have.
And I think you've also made these submissions yesterday as well.
I'm sorry, my lord. I can leave it there. That is the end of the submission. In fact, I referred you yesterday to Young and Bristol Aeroplane, and that's very familiar to my lords. And one of the grounds on which the court can depart from its own decisions is if a case which is binding upon it is not referred to it. Now, of course, I can't tell you that Macarazzi is a case that's binding on you, but of course, by Section 3 of the Human Rights Act, it would have been a case to which you would have been obliged to have regard had it been drawn to your attention.
Section 2.
Sorry, my lord.
Section 2 of the Human Rights Act. Yes.
And so we respect.
Well, I don't think you need to develop a Young and Bristol aeroplane argument. The straightforward proposition is that if there's a settled seam of authority from Strasbourg, we follow it, and that's how Section 2 has been interpreted. And what you're saying about the case of Macarazzi is that it's simply an example of, it's a third chamber decision. I think it's an example of the settled line of authority that starts with Jordan and flows through countless cases since. So it doesn't. It's not a case, as I see it, that adds any new propositions of law at all from Strasbourg. Your submission is, if I may say so, a very straightforward one, namely that it's an example which should lead to the conclusion that aspects of the Tyrrell judgment are not correct, but you've also submitted that that doesn't matter because Tyrrell, as you rightly observe, was concerned with deaths from natural causes.
And, yes.
And that's its boundary, but there we are. Okay.
I can deal very quickly then with a question from my Lord Justice Baker yesterday, which was, what is the standard of proof where the presumption is raised in an Article 2 case or an Article 3 case, and the state has to provide a satisfactory and convincing explanation for the death. My learned junior has been beavering away, my lords, and the fact that he's only pulled up one case should not give the impression that he's not being very diligent, because we couldn't find any cases apart from one from the Court of Appeal in Northern Ireland, yes, which I hope is available and now on your desk. If I can ask you to turn to paragraph 116 of that judgment. This is one of the Therese Jordan cases, in which there were many in Ireland. Of course, it's the same Jordan that went to Strasbourg. All I need to draw to your attention is that the coroner applied the civil standard of balance of probabilities to the state's duty of providing a convincing and satisfactory explanation. You see that from line 5 in paragraph 116, that sentence. That approach was not appealed, but nor was it commented on or criticised by the Court of Appeal in that case. And so I think we can take that both sides were content with that approach. So the answer to my Lord's question, unsurprisingly, is that if the state is under a duty to provide a satisfactory and convincing explanation, they may do so by proving on the balance of probabilities that there's been no breach.
But that would, of course, that would be if the tribunal concerned were to decide whether there has or hasn't been a breach of Article 2, which is not what an inquest does. But thank you, and thank you very much, to Mr. Clark for having done the research overnight. So that was the second question, and I think there was a third question you were going to.
That was the third.
That was the third.
I think I might have conflated the questions, my lord. I think I've dealt with.
Thank you, Mr.
Byrne.
Byrne.
Which was whether I needed to distinguish or depart or persuade you to depart from.
Yes, you're quite right.
Throughout.
Good.
My lords, unless I can give any further assistance, those are my submissions.
Thank you very much indeed, Mr. Bowen. Now, Mr. Hoff, we obviously appreciate that you are here for the coroner. We have very much in mind the basis on which you appear, and also understand entirely why. From our perspective, it would be helpful if you were to approach your submissions as if you were an advocate to the court, which to our mind marches very comfortably with the approach that those appearing for coroners tend to adopt.
Yes, my lord. And it's in that spirit that the supplementary skeleton argument was drafted, as I hope my lords and my lady appreciate.
Yes.
So, my lords and my lady, just for the benefit of others listening to this hearing, the coroner's position is non-adversarial, but seeking to assist the court on points of law of wider significance in particular. If it's convenient, I propose to make submissions in 5 main parts, following broadly the order of Mr. Bowen. First of all, to deal with a very small number of points of fact by reference to the material before the coroner. Secondly, to consider the legal principles governing inquests and Article 2 procedural and substantive obligations, which will be the longest section. Thirdly, briefly to address Appeal Ground 1, whether the Trust owed an Article 2 operational duty to protect Tanya Morahan from the risk of death from drugs such as cocaine and heroin. Fourthly, briefly to address Appeal Ground 2, whether the Article 2 procedural obligation of enhanced investigation, as articulated in the Jordan case, was engaged automatically. And fifthly, briefly to address Appeal Ground 3, whether the Article 2 procedural obligation was engaged in that sense on the basis of there being an arguable case on the material before the coroner that the Trust had breached an Article 2 operational duty in relation to Tanya Morahan's death. I should make one point at the outset about the structure of the legal analysis. We say that the question whether the Article 2 procedural obligation is engaged on the basis of arguable breach, so not automatically, but arguable breach of an operational duty divides into 2 sub-issues. First, did the relevant public authority owe a duty to protect a person in the position of the deceased against the relevant type of risk of death?
Sorry, could you just repeat that?
Yes. Did the relevant public authority owe a duty to protect a person in the position of the deceased against the relevant type of risk of death? And secondly, if so, did it arguably breach that duty? And that question often involves the application of the Osmond test. Now, in our submission, it is more straightforward in keeping with the authorities to consider in this way the existence and scope of the duty, and then whether any duty was breached. Mr. Bowen frames the approach slightly differently, saying that one first asks whether a duty was owed in principle, and secondly, a composite question of whether the duty was owed and breached on the facts. And for my lord's and my lady's reference, that's paragraph 26 of his skeleton. There may not be much between ourselves and Mr. Bowen in this regard in practice, because we accept that it's a question of law whether a duty is owed on a particular set of facts. And we also accept that in some cases, like Raybone, the courts have decided that in principle an operational duty is owed to protect all persons in a particular situation against one or more forms of fatal risk. But first of all, it is always a little hazardous to consider the existence of duties in a factual vacuum, as the civil courts have often said. But secondly, and more importantly, it is vital to keep in mind the scope of the relevant duty. An Article 2 operational duty is usually framed as a duty to protect persons in a certain position from one or more forms of risk of death, not all forms of risk. The purpose and scope of the duty of the public authority are closely aligned with each other. And whatever taxonomy we adopt, we need to bear that principle in mind. As regards the fresh evidence application, I can deal with that at the end as necessary. We've set out the governing principles in our skeleton. But we just make 2 points in relation to that. First of all, the coroner, if her decision were upheld, would of course keep it under review and take account of any further evidence that was put to her, including the report of Dr. Langford, and in doing so would give very considerable weight, obviously, to anything my lords and my lady said about that report. And secondly, respecting entirely Mr. Bowen's point about artificiality, the application does raise a point of principle about whether a coroner's decision on Article 2 engagement can be reviewed based on evidence that was not before him or her, and in what circumstances that can happen. Whether one can really go so far as to say that in a case involving human rights, the field is entirely open on review for evidence subsequently obtained. So, for that reason, we'd urge my lords and my lady, while considering that application seriously, to bear in mind its potential consequences. So with those opening remarks, may I turn to factual background, which, as I say, I will take swiftly. My lords and my lady will need the supplementary appeal reports. Once we've dealt with that one for this purpose, we'll put it aside.
Just a moment.
No, it's all right. I spilled a little bit of water. Don't worry. It's not very much.
Just come. Are we going to look at what the coroner said about the facts?
Well, what I was going to do was look at some of the material before the coroner in light of some of the submissions yesterday, but I'm happy to go to one of the decisions.
Yes. But that's the starting point, isn't it? What the coroner said?
Well, I'm very happy to go to what the coroner said, but the point correctly made by Mr. Bowen was that it was for the divisional court to decide on the basis of the material before the coroner whether the Article 2 obligation was engaged for itself. It wasn't merely a rationality review, which is why we're tending to start from a relatively clean slate. So may I begin with the background to the December 2017 admission? And if my lords can turn up the social circumstances report for the first tier tribunal, divider 5, page 30. Supplementary bundle, divider 5, page 30. And this provides a good background history from page 31 to 32. And I'd like quickly to identify a few points of fact from that history. First of all, Tanya Morahan's clinical history, which we see dating back to 2008, is characterised by psychotic disorder, including auditory hallucinations and paranoid delusions. My lords will see that in the entries for April 2013, September 2014, and August 2015. My Lords will also see, secondly, that there were periods of engagement, there were periods when Tanya Morahan did not engage with mental health services, including 2008 to 2011, October 2014 to August 2015, and early 2016 to mid-2017. In the summaries on relapse in 2015 and 2017, it was suggested that Tanya Morahan had not continued her medication, which partly explained the relapse.
Where's that?
August 2015, my lady, sixth line down. In the August 2015 entry, and then for 2017, it's the first line on page 32.
Yep.
And then on page 32, there's a summary of events leading to current admission, which refers similarly to psychotic thoughts and self-neglect. And there is reference to the positive opioid test in line 4. So that's the clinical background. May I refer briefly to a medical note Mr. Bowen showed my lords and my lady yesterday, divider 1 on page 3. And this is right at the bottom of the page. The opioid test result of the 3rd of December 2017. Positive for cocaine and or opioids. Now, as we read it, though there's reference to increased cardiac rate, that doesn't necessarily reflect an overdose in the sense of drug use likely to cause immediate and very serious harm. I just mentioned that because it was suggested yesterday as being indicative of overdose in that sense.
It is simply saying it was found.
Yes.
As the summary on 31 you just showed, that's the same.
We
It's the
believe
same
it's the same test. Yes, my lord.
Yeah.
Does make sense. And my lord saw from paragraph 124 of the judgment that the divisional court was very aware of that test. Turning then to the admission for treatment in late December 2017, may I look briefly at the approved mental health professionals assessment, divider 3 of the supplementary bundle, just to refer to 2 entries in that on page 17. And here I'm referring to sections 10b, risks, and 10c, views of the assessing doctors. Under risks, Tanya Morahan was assessed as unwell, thought disordered, suffering from a severe psychotic episode, vulnerable to exploitation from others, difficulties with communication, but no history of self-harm or suicide. 10c, views of the assessing doctors, similarly referred to a severe relapse with poor self-care, lack of capacity, and over the page, she misuses illicit substances which affect her cognitive ability. I mentioned that because it needs to be borne in mind when we look at subsequent references to assessment by clinicians of the effects of such substances. Then, my lord, over the following months, from May to June 2018, to May and June 2018, Tanya Morahan apparently progressed well with her treatment and with her occupational therapy support. Now that's summarised by Dr. Rahim in her witness statement. My lords can choose whether or not to turn it up, but it's at divider 16, page 110, paragraph 34. And Dr. Rahim refers to her doing well with no sign of mood disorder or psychosis, attending occupational therapy groups, and mentioning that it would be difficult to justify extending the section when it expired at the end of June. Now, at the bottom of page 110 to 111, column green, that was the unit wanted an extended period of successful unescorted leave with negative drug screens. And then over the following pages, Dr. Rahim refers to positive progress with various references to successful use of unescorted leave. My Lord's note, that's paragraphs 36, 42, 45 and 48. I refer to those because, of course, they are context for the ward round document my Lords and my Lady were shown yesterday by Mr. Bowen, which is at divider 8. I'd like to pick up a couple of factual points on this. Page 55, the end of the first main paragraph. There has not been any psychotic symptoms of her mental illness. Staff have observed, and she's always been appropriate in behaviour. No issues of any drugs or alcohol. Tests taken for both have been negative. And if we go to page 57 at the bottom, there is recorded an interview with Tanya Morahan. Look right at the bottom of that page, she admitted she'd been using alcohol and drugs to self-medicate, pointed to her drugs tests having been negative, and then going down to the second main paragraph on page 58, Tanya Morahan was aware of her section ending, said she would be really low if it was renewed. She was happy to stay as an informal patient working with occupational therapy, building up her CV and engaging with the care plan. I stressed working with the occupational therapist because that helps make some sense of an entry which my Lords and my Lady were shown yesterday. So page 59, my Lords and my Lady yesterday were shown an entry under the action plan, fourth item. Tanya agrees to only return home with OT accompanying her for now. We're not sure that that suggests that there was any suggestion that she should be accompanied home for her own protection, rather than as part of the exercise of helping her get her home ready, working with the occupational therapist. Moving then to the first absence without leave between the 30th of June and the 1st of July 2018, my Lord saw that that was documented in the running notes of column green at divider 7, beginning at page 49, and then running through the pages in reverse order, so pages 47, 49, 48, 47. And as my Lord saw, she was off the ward from mid-afternoon, failed to return in the evening, made the call in the morning expressing regret and promising that she would return. And then she returned as promised the next day, in fact ahead of time, and gave negative alcohol and drugs tests. And in answer to a point raised by my Lord Justice Baker yesterday, I think I counted that she was reviewed 5 times by clinicians over the following 24 hours. as I say, pages 47 and 49. As the court saw yesterday, Dr. Rahim in her statement explained that the team saw no ground to detain her in these circumstances. For my Lord's note again is paragraph 51 of her statement, divider 16, page 116. And Mr. Bowen is quite right to say that there is no entry in the notes documenting a positive decision not to detain Tanya Morahan or revoke her leave. Simply observe that may reflect the fact that this was a view taken by her in discussion with the other clinicians rather than at a full meeting.
Can I ask how you're using the phrase clinicians?
I'm sorry?
May I just be clear, how are you using the phrase clinicians?
To include the registered mental
That's what I wanted to
nurses
know.
on the team as
The
well
RMN.
as the exactly.
Right.
Now, against that background, Mr. Bowen took you yesterday to a risk assessment, divider 9, page 60. And I just refer to a few entries in that on page 61.
Could you remind us of the date of the risk assessment?
This risk assessment was on the 2nd of July 2018, so the day following her return to the ward on the previous late afternoon. So page 61, the assessment at item 7, entry 7, was that there was no known risk of deliberate harm to self. There was a risk, item 8, of harm to self through neglect. There was a high risk to this person through substance misuse, but at item 10, no known risk to physical health. And that tick box set of entries can be understood when one looks down to the entry under context at item 14, which says that Tanya Morahan had a vulnerability to taking illicit substances and misusing alcohol, which leads to a deterioration in her mental health. So certainly this document was suggesting that the perceived risk from substance misuse was to mental health. Of course, Mr. Bowen can say that there should have been an appreciation of another sort of risk because of the prolonged abstinence.
I'm sorry, I just dropped your voice then.
I'm sorry. Mr. Bowen can say that there should have been another sort of risk appreciated because of her prolonged abstinence from
Yes.
illicit
Thank you.
recreational drugs. Sixthly, next, my lords, the second absence, as my lords are aware, this is documented at divider 7, page 46. Tanya Morahan left the ward on the morning of the 3rd of July, saying she was going to tidy her flat, then in the evening called to say that she was in Essex and would return later. When staff told her that she was on evening medication, she replied, "I have a life." From that point in time, staff tried to call her numerous times. They acknowledged she had a history of substance and alcohol abuse misuse, and they therefore informed the police requesting a welfare check. My lords have the police call transcript, divider 10, page 67. Attempts to contact her continued over the following days, documented at pages 44 to 45 of the notes. And Dr. Rahim decided on the 5th of July that on Tanya's return she should be assessed for potential admission under section. That's page 43. And Mr. Bowen yesterday suggested that there was an uncertainty about whether the care coordinator had been informed. All we can say about that is that we do know that an email was sent to her on the 6th of July 2018, as my lords and my lady will see from page 41. Mr. Bowen also suggested that the Trust had failed to comply with its policy on absences without leave by not doing more to track down Tanya Morahan. Now, I'm not going to engage with this as if adversarially, but I would suggest reading the relevant section of the policy on absences, which is at divider 21, page 163, paragraph 4.2, in particular 4.2.4 to 4.2.6, page 163. My lords and my lady will take a view about whether that dictates staff, how much that dictates staff tracking down patients, as well as asking the police to make contact. And then finally, on points of fact, of course, my lords and my lady are aware that police attended Tanya Morahan's flat on the 9th of July, and they found her very sadly dead. Cause of death, as determined in the post-mortem examination, being cocaine and morphine toxicity. Lords and my lady are then aware of the answers that the pathologist gave to questions. First of all, that use of opiates could have been more dangerous due to loss of tolerance, and secondly, that based on the state of the body, she probably died closer to the 3rd of July than to the 9th of July. I only add in this regard that there was a suggestion in argument yesterday that the Divisional Court judgment of paragraph 124 suggested that it rejected Dr. Chapman's evidence on concerning loss of tolerance. But all we'd say is that we don't read paragraph 124 as rejecting that evidence. So that's a whistle-stop tour of the factual background, and I hope not too long. My lords and my lady can set aside a supplementary bundle. May I begin then with the relevant legal principles? The starting point is the domestic law on coronial investigations and determinations, which is affected by the Article 2 procedural obligation where it applies in the relevant sense. That domestic law is summarised from paragraph 6 of our supplementary skeleton argument, which is in the core bundle, right towards the end, divided 33, unless my lords and my lady have it separate. Mr. Bowen took you through the relevant parts of the Coroners and Justice Act, so I shan't do so again. I'll just pick up a few points briefly. As my lords and my lady saw, a coronial investigation must take place where there's reason to suspect that a reported death was violent or unnatural, or that it took place in state detention. That's section 1.2. As Mr. Bowen stressed yesterday, the investigation must include an inquest, except in circumstances covered by section 4, where a post-mortem investigation report establishes the death to be of natural cause and an inquest is unnecessary. That section 4 procedure is known as the Pink Form B procedure because of the form that was used in those cases. That procedure can't be used, as you heard, for deaths in custody. Now, there was a suggestion at various points that these domestic law provisions accorded with aspects of convention law. We would only observe that the domestic legal framework in sections 1, 4 and 6 is largely unaltered from the Coroners Act 1988, which was itself a consolidating act, consolidating legislation going back 90 years or so. The framework was not designed to accord with the Strasbourg case law. And so one shouldn't interpret the requirements of Article 2 in domestic laws if it were. Sections 5 and 10 govern respectively the purpose of an inquest and the conclusions to be expressed, focusing on the 4 key statutory questions of who, how, when and where. As my lords know, the effect of the Middleton case is that the how question bears the broader meaning of by what means and in what circumstances, rather than simply by what means, in cases where the Article 2 obligation of enhanced investigation, the Jordan-type investigative duty, is engaged. It was the Hurst case that decided that that broader approach to inquest determinations only applies in cases where the relevant Article 2 procedural obligation is engaged. Now, as my lord, the Lord Chief Justice said in the Maguire case at paragraph 77, which need not be turned up, the decision that the relevant obligation is engaged primarily affects the determinations at the end of the inquest, usually has no or little effect upon the scope of inquiry, preparation for or conduct of the inquest hearing, and that's because the scope of inquiry is a matter of broad judgment, and a properly conducted inquest will ordinarily consider the broad circumstances of death. Mr. Byrne very fairly accepted that that's the coroner's intention here. A finding that the Article 2 procedural obligation is engaged may also have an effect on the availability of legal aid for representation in an inquest. It doesn't necessarily dictate that legal aid will be available, as paragraphs 20 to 21 of the Lord Chancellor's guidance make clear, but it certainly helps the application. But as my lord said yesterday, that's not a consideration which can influence a coroner's decision, however much he or she may think that the bereaved family might benefit from funded representation. And that's because the question whether the Article 2 procedural obligation is engaged is not an exercise of discretion where the consequences of the decision are taken into account. It's a question of law. May I then turn on to the engagement of the Article 2 obligation, procedural obligation, based on arguable violation of the substantive right. As Mr. Bowen said yesterday, the obligation is only engaged ordinarily if on the available material there is an arguable case that the state or its agents breached one or more of the recognised Article 2 substantive duties in relation to the death. Now that was established in this country in a trilogy of cases, Goodson, Tacucius and Humberstone. May we return very briefly to the third of those, Humberstone. My lords and my lady will find in the authorities, first authorities bundle, divider 18. This concerned challenged a refusal by the Legal Services Commission to grant public funding for representation at the inquest of a young boy who died following an asthma attack. And this court considered the circumstances in which the Article 2 procedural obligation is engaged in the relevant sense because of its relevance to public funding. Lady Justice Smith, in the leading judgment, dealt with the engagement of Article 2 from page 52, paragraph 52 on page 459. And as my lords and my lady were told yesterday, she there distinguished between the two forms of procedural obligation under Article 2. One on the state to have a functioning system of civil and criminal justice by which any death involving an allegation of negligence or misconduct by public authorities may be investigated. And second, she put it by letter H, there is a duty proactively to conduct an effective investigation into the circumstances of a death in a much narrower range of circumstances where the evidence suggests a possible breach of the state's substantive duty to protect the life of those in its direct care. I stress or underline the evidence suggests, because this is a judgment based on available facts rather than upon speculation. From paragraph 54 on the next page, Lady Justice Smith traced the line of reasoning in the Goodson and Tacucius cases which supported that analysis. Now, in summary, the courts in those cases had drawn from the medical cases in Strasbourg, such as Powell and Vaux, a consistent approach of finding that the state was not obliged to conduct an enhanced Jordan-type investigation, where the only allegations were of simple clinical negligence and no violation of the substantive Article 2 right to life could be established. And from that approach by the Strasbourg courts, our courts, Mr. Justice Richards in Woodson, Sir Anthony Clark in Tecutius, and Lady Justice Smith in Humberstone, drew the conclusion that the duty of enhanced investigation, as it was described, only applies where there has arguably been a violation of the substantive right to life. Lady Justice Smith in particular summarised that approach of our courts in paragraph 58 on the top of paragraph 61. She then, at paragraph 67, drew the conclusions which I think were shown yesterday, which effectively reflected what she had begun the section with in paragraph 52. Immediately before that paragraph 67, she had pointed out that reasoning was consistent with the view expressed by Lord Bingham in the Gentle case, that the relevant type of procedural obligation is parasitic on or dependent on there having been an arguable violation of the substantive right to life. Now, nevertheless, the UK courts have recognised that there are some categories of case where the relevant Article 2 procedural obligation is engaged without the need for a specific basis in evidence for saying that the Article 2 substantive duties were arguably breached. That is automatic engagement, as it's been referred to. I propose to deal with that now. I've addressed it in some detail from paragraph 15 of the skeleton by reference to L, Smith, Letts and Tyrrell, but I propose at the moment just to go to the Smith case. My lords and my lady will find in the second authorities divider 40 or 0. This is, of course, the leading domestic case on this subject. Concerned the death of a soldier on active service in Iraq due to hypothermia after operations in extreme heat. Much of the judgment is concerned with the territorial application of the Convention. Subject to that issue, the court held that the procedural obligation was engaged, but on the basis of an arguable breach by the state of the general duty. It was not engaged on an automatic basis which would apply to all soldiers on active duty. That was the ratio and conclusion. May we then go to Lord Phillips's judgment, which I know you've been taken to already, just to deal with a couple of points. First of all, paragraph 84 on page 1184. Here, Lord Phillips is rejecting the argument that the obligation is automatically engaged, and he says, by letter E, I don't consider that the death of a soldier on active service of itself raises a presumption that there has been a breach of those obligations. The next sentence is important. Troops on active service are at risk of being killed despite the exercise of due diligence by those responsible for doing their best to protect them. Death of a serviceman from illness no more raises an inference of breach of duty on the part of the state from the death of a civilian in hospital. As we read that passage, when he refers to a presumption of breach, he appears to be speaking of a natural inference rather than a presumption of law dictated by policy considerations. And also, my lady, then turn the page to 1185. Just for completeness, paragraph 87 is where Lord Phillips finds that the Private Smith's death on active service does, in fact, itself give rise to a suspicion of breach on the evidence before the coroner. And on these issues, the majority of the court agreed with Lord Phillips. So that's Barons Hale at Para 137, Lord Walker at Para 131, Lord Brown at Paras 150 following, Lord Collins at Para 309, and Lord Kerr at paragraph 340. The next judgment my lady was shown is that of Lord Hope, 1188, paragraph 98. And he observed that some situations in which the procedural obligations triggered are now well recognised. He referred to the suicide of an individual in custody as a prime example and gave this reason. This is because it's been recognised that prisoners as a class present a particular risk of suicide, and because those who have custody of them as agents of the state are or may be in some way implicated. And then he says this: a Middleton inquest is required in all these cases because it is at least possible that the prison authorities failed to take the steps to protect the prisoner's life. The procedural obligation extends to prisoners as a class, irrespective of the particular circumstances in which the death occurred. The fact they're under the care and control of the authorities by whom they're held gives rise to an automatic obligation. And then at the end he referred to the approach having the merit of clarity, that everyone knows that a Middleton inquest is needed from the start. Once again, we see that as consistent with a view that the circumstances raise a natural inference that substantive obligations may have been breached. And then thirdly, Lord Roger, page 1193, from paragraph 116. Referred to his own judgment in the L case. And at the top of 1194, quotation from that case includes the passage: whenever a prisoner kills himself, it's at least possible that the prison authorities who are responsible for the prisoner have failed either in their obligation to take general measures, so the general duty, to diminish the opportunities for prisoners to harm themselves, or in their operational obligation to try to prevent the particular prisoner from committing suicide.
So that language you say is consistent with an inference.
Yes.
If the circumstances give rise to inference rather than any question of presumption.
Rather than a presumption of law dictated by policy. Yeah. And we'd say that the same flows from paragraphs 117 and 118 of Lord Roger's judgment, where he says that, where he recognises the obligations of the prison authorities, and then says at G, the mere fact that the prisoner has committed suicide indicates that there may have been a failure on the part of the prison authorities to perform their Article 2 obligations to prevent those in custody from doing so. And he draws an analogy of paragraph 118 with raw recruits during initial military training. So the approach appears to be there are some categories of case where the happening of death in a particular way raises an inference that the state arguably failed to comply with its positive substantive duties to protect life. And in those categories, the Jordan-type duty of enhanced investigation is engaged without the need for evidence of specific failures. Those categories including suicides and other violent deaths in prison, and also suicides of conscript soldiers and those detained under the Mental Health Act. And Mr. Bowen argued that the state owes an operational duty, that when the state owes an Article 2 operational duty to a person, and the person dies in circumstances where the facts are mainly within the knowledge of the state has to account for the person's death. And the forensic tool requiring that account to be given is a presumption of breach and automatic engagement of the enhanced investigative obligation. That argument is derived in large part from various statements in Strasbourg cases which say that the state owes a duty to account for serious injury or unexpected deterioration in the health of a prisoner, and where the failure to give such an account may give rise to a presumption of wrongdoing by the state. We can address that by reference to a couple of the authorities in Bundle 3 from the European Court of Human Rights. We'll put aside Bundle 2 and take up Bundle 3. First of all, Salman at Divider 61. I picked this because it was an early case to identify refer to presumptions. It was a case of violation of Article 2 on the basis of a man dying as a result of torture in police custody. The Article 2 claim is dealt with from 2128, paragraph 97. And this section from paragraph 97 concerns the claim for breach of the substantive obligation rather than the procedural investigative obligation. Paragraph 99, my lords and my lady were shown yesterday, begins with reference to the vital importance of the protection afforded by Article 2, refers to the vulnerability of persons in custody. Then the court says, consequently, where an individual is taken into police custody in good health and is found to be injured on release, it's incumbent on the state to provide a plausible explanation of how those injuries were caused. Now, similar obligations to account, presumptions are referred to in caps in the context of suspicious circumstances deaths. And as we'll see in Makaradze, in a case where there was a sharp deterioration, as it was put, in the health of the prisoner. But we would observe, just before moving to Makaradze, that these statements feature in parts of the cases concerned with proving breach of the substantive obligation, where the court explains that it may find a breach where death has occurred in circumstances which give cause for concern and for which the state has not accounted properly. So the court is saying that the ordinary burden standard of proof can be bypassed where death has occurred in circumstances which give cause for concern. We go to Makaradze, which no friend placed particular reliance on, that's at Divider 57. This was a prisoner diagnosed with tuberculosis whose condition deteriorated and he died. the background included a hunger strike period, and the allegations were a failure to provide adequate care. Now, in this case, the relevant section, paragraph 71 on 1937, under the general principles heading, stated that persons in custody are in a vulnerable position and the authorities are under duty to protect them. Paragraph 72, the authorities must account for the treatment of persons deprived of their liberty. A sharp deterioration in a person's state of health in detention facilities inevitably raises serious doubts as to the adequacy of medical treatment. Therefore, thus, where a detainee dies as a result of a health problem, the state must offer a reasonable explanation. And then there's reference to the Katz case in that context. And the court goes on to find, paragraph 89 on 1943, that the state had in this case failed to account sufficiently for the death. That leads the court to conclude at paragraph 90 that the state can't be said to have undertaken adequate measures to prevent the lethal outcome. Now, as we read Makaradze, that was not a case which actually focused upon or addressed a breach of the investigative obligation. It was concerned with the substantive obligation. And it's easy to see why this approach is taken to questions of proof, where death occurs in concerning circumstances, and the state, which has all the evidence, fails to account for death. But we would respectfully question whether that approach bears on automatic engagement of the Jordan-type investigative obligation. And in any event, we would question whether it requires automatic engagement in all cases of deaths in custody. When dealing with Tyrrell this morning, Mr. Byrne appeared to suggest that it might not, at least in natural causes cases, where precisely the line is to be drawn, we find a little unclear. Two final points in relation to automatic engagement, which we don't think are controversial. First of all, we would respectfully endorse the view of Lord Justice Popplewell, where there is this form of automatic engagement of the procedural obligation, it has to be on the basis of what he called a category exercise. Automatic engagement has to apply to a whole category of deaths, such as violent deaths in prison or suicides of those detained under mental health legislation. It can't depend on particular characteristics of the deceased or factual quirks of the case. We say that for two reasons. First of all, because the authorities which have referred to such automatic engagement treat it as such a category exercise, and we saw that in the Smith case. And secondly, if it's not a category exercise, then it's difficult to see what purpose it serves and what it adds to engagement on the basis of automatic, of arguable. The second point we'd make is that a coroner who has to decide a question of Article 2 engagement can't fudge the issue or err on the side of finding the obligation is engaged, because the cases show that an unjustified decision that Article 2 is engaged can be reviewed as readily as an unjustified decision going the other way. So that's what I propose to say about the procedural obligations. May I now turn to Article 2 substantive obligations. Now, in simple terms, we have the general or framework duty on the state to establish a framework of law and procedures to safeguard life. And then we have operational duties to avert particular risks to the lives of individuals, which are owed by state agents and agencies in what the European Court always calls well-defined circumstances. An Article 2 operational duty is a duty the breach of which involves the state being called to account for violation of the citizen's right to life. And as such, both the reach of such duties and the criteria for breach have been tightly controlled. In the supplementary skeleton argument, paragraph 22, I sought to chart the development of Article 2 operational duties. Against that background, I'd like to address three aspects of these duties. First of all, their development. Secondly, their scope. And thirdly, conditions for breach. So development of the duties. We can take this usefully from the case of Stoyanovi, which I don't think my lords and my lady have been taken to. It's Divider 62 of the third authority document, which you may still have in front of you. Divider 62 towards the end. And this was a case where two paratroopers died during helicopter jumps, which were badly organised, and they struck the wheels of the helicopter. Now, from paragraph 59, on page 2163, the court described the development of operational duties. And in paragraph 59, second sentence, about 5 lines down, stated, in certain well-defined circumstances, the obligation may extend to requiring the authorities to take preventive operational measures to protect an individual whose life is at risk from the criminal acts of another individual. So that's Osman. And then the Osman test is articulated towards the bottom of that page. And the rest of the paragraph, on page 2164, the court explains that that approach has been upheld in the field of environmental protection. That's Honor Yildiz. Paragraph 60, the court explains that positive obligations apply in the public health sphere, but to take general measures for the protection of patients' lives. Rather than operational duties which are breached by simple medical negligence. Now, paragraph 61, the court says this: positive obligations will vary in their application depending on the context. Primarily the task of domestic systems to investigate the cause of fatal accidents and to establish facts and responsibility. In the present case, which concerns an accident during a military training exercise, the court notes that while it may indeed be considered that the armed forces activities pose a risk to life, this is a situation which differs from those dangerous situations of specific threat to life, which arise exceptionally from risks posed by violent, unnatural acts, unlawful acts of others, or man-made or natural hazards. The armed forces, just as doctors in the medical world, routinely engage in activities that potentially could cause harm. It is, in a manner of speaking, part of their essential functioning. Missing the next sentence, wherever a state undertakes or organises dangerous activities, it must ensure through a system of rules and through sufficient control that the risk is reduced to a reasonable minimum. And that, we would suggest, is primarily a reference to the general duty. And if damage nevertheless arises, it will only amount to breach of the state's positive obligations if it was due to insufficient regulations or insufficient control, not if the damage was caused through the negligent conduct of the individual or the concatenation of unfortunate events. And as we'll see, that mirrors the approach taken in the clinical cases. Maybe then turn briefly to Lopez de Sousa Fernandez for the clinical cases. That's Divider 56. I can deal with this very briefly because you were shown this yesterday. Page 1858. 186 to 187, the court reaffirmed the Powell and Vaux line of authorities that in the context of alleged medical negligence, the substantive positive obligations were limited to the framework duty, and that a breach could not be established simply on the basis of medical negligence or negligent coordination between professionals. Then, as Mr. Bowen said, from paragraph 190, the court identified the two exceptional circumstances in which the state could be held to account under Article 2 for the acts and omissions of healthcare providers, which was patient's life knowingly being put in danger by denial of access to treatment, and systemic failure leading to deprivation of life-saving treatment. As my lady can put aside volume 3, the final case I'm going to go to at this point is the Ray Bone case, again which I can take relatively briefly. That is in Authorities 2, Divider 37. In this case, Lord Dyson, as my lord and my lady saw yesterday, put forward a framework to help decide where an Article 2 operational duty would be recognised in a new situation, a sort of Capara and Dickman moment for conventional law. And it established that an Article 2 operational duty was owed to protect a voluntary psychiatric patient who was known to be suicidal against the risk of suicide. Now, I stress against the risk of suicide because at every stage the justices limited their reasoning to that form of harm. Don't say that they sought to exclude further development. That is what they were dealing with. So if we pick up the judgment of Lord Dyson at page 975, paragraph 15, he surveyed the development Article 2 operational duties where they've been found to be owed in a way similar to the approach of the court in Stoyanovi. If we turn on to 977, paragraph 21, having considered the cases where the Article 2 operational duty had been found to apply and those where it had not, he said it was necessary to attempt to discover the essential features of the cases where Strasbourg had so far recognised the existence of an operational duty. It's clear that the existence of a real and immediate risk to life is a necessary but not sufficient condition for the exercise of the duty. And he based that on the simple point that a patient on the operating table may be at a real and immediate risk of death, but isn't owed the conventional Osman duty. In paragraph 22, he identified the three indicia from the case law. I return to these because when considering these indicia, it is important to reflect on the cases which Lord Dyson instanced as representing those indicia. The first of them was assumption of responsibility by the state. That is paragraph 22, 3 lines to the bottom. And that was said to be significant in cases where persons were detained, whether in prison or a psychiatric hospital or in a detention centre. That explained the duties to safeguard them, as he said, from suicide and other violence. Paragraph 23, he addressed vulnerability of the victim, referring to circumstances of sufficient vulnerability. And the example he gave in that case was Z, which concerned young children at risk from physical and sexual abuse. And the third example he gave was the nature of the risk. And there he referred to the distinction drawn in Stoia Novi between risks which are endemic and those which are exceptional. He then, from paragraph 26, addressed the central question of whether a duty was owed in this case. Paragraph 28 he referred to the fact that differences between an informal psychiatric patient and one detained under the Act may be more apparent than real. And a few further lines down, he said that an informal patient may be treated in a secure environment in circumstances where she is suicidal, receiving medication for her mental disorder which may compromise her ability to make an informed choice to remain in hospital. Dropping down a few lines, the statutory powers of detention are the means by which the hospital is able to protect the psychiatric patient from the specific risk of suicide. Over the page on paragraph 30, we return to the same theme, the second line. In the case of the suicide of the psychiatric patient, the likelihood is that given the patient's mental disorder, the capacity to make a rational decision to end her life will be to some degree impaired. She needs to be protected from the risk of death by those means. And then turning to Melanie's case, he said that the very reason why she was admitted was because there was a risk she would commit suicide from which she needed to be protected. Paragraph 33, one line up from the bottom, he referred again to Strasbourg jurisprudence demonstrating a duty to protect against a real and immediate risk of suicide. And his conclusion at paragraph 34 was that the trust owed an operational duty to Melanie to take reasonable steps to protect her from the real and immediate risk of suicide. Adding between letters B and C that she had been admitted to hospital because she was a real suicide risk. Pausing there, my lords and my lady will have seen that Lord Dyson referred to the existence of a foreseeable risk of foreseeable real and immediate risk of death as being a necessary condition for the existence of the duty. And that is why Lord Justice Popplewell said that the existence of that risk was an ingredient in the duty rather than in the breach test. Mr. Byrne takes issue with that conclusion. This may be more a question of nomenclature than substance, because we all agree that a foreseeable real and immediate risk of death must be found before the duty is triggered. So whether one cites that ingredient in the duty test or in the breach test, the effect is the same. Now I then turn to the scope of Article 2 operational duties. And we say that an important feature of those duties is that where they are recognised, they are duties to safeguard against particular forms of risk of death, not against every form of risk. I propose to refer to two cases to make that good. The first is the Mitchell case, which I don't think you've been shown, which is Authorities 2, Divider 31. This was a claim pleaded in negligence and under the Human Rights Act against a local authority for failure to protect one secure tenant against the risk of harm from a threatening neighbour. And Lord Roger gave the significant judgment for present purposes on page 827, dealing with the Article 2 claim. He outlined the general and operational duties of paragraphs 65 and 66. Then at paragraph 67, he referred to the lack of proper pleading of an appreciable, real and immediate risk of death. In the last sentence he said, even leaving that matter on one side, the pursuer's Article 2 case is fundamentally irrelevant. Of course, it's Scott's legal language for without legal basis. He went on to say, paragraph 68, that it was the local police force who were responsible for preventing criminal violence, and that force could owe an Article 2 operational duty to protect citizens against such violence. Paragraph 69, he said that the local authority was in a different position. They could be in breach of an Article 2 duty if they allowed housing stock to fall into disrepair, giving rise to a risk of death. But they didn't have the responsibility to protect against criminal violence. Page 829, by letter B, he said that he saw nothing in the relationship of landlord and tenant to give rise to any Article 2 operational duty to protect Mr. Mitchell's life against the risk of attack by his neighbour. So the council did owe Article 2 duties to protect Mr. Mitchell against some risks, and that those risks were the risks which reflected its particular field of responsibility, but not against all risks. The other decision is that of this court in Maguire, to which I turn briefly because my lord and my lady haven't been shown it in this case, I think. Obviously, my Lord Chief Justice and Lady Justice Nicola Davies will be very aware of it. It's at Authorities 1, Divider 28. This was a case about a woman with Down syndrome, Jackie, living in residential care and subject to a dole's authorisation under the mental capacity. She became very ill and died in hospital, the complaint being that she should have been taken to hospital sooner. The court held that the Article 2 procedural obligation wasn't engaged because there was no Article 2 operational duty to protect Jackie against this particular form of risk of death. You can pick it up at paragraph 70 on page 725. Right at the bottom of page 725. My Lord summarised the underlying argument of the claimant was that as being that the vulnerability of someone in Jackie's position along with the dole's authorisation dictated that she was owed the operational duty. Paragraph 71 to 72, the court stressed the need to focus on the scope of the duty and explained that its key characteristic was one of state responsibility. In paragraph 73, the court said this, and this is a particularly important passage. Both the prison cases and those concerning conditions within an institution where vulnerable people are cared for, as a reference to the Nincheva and Campiani cases, demonstrate the Article 2 substantive obligation is tailored to harms from which the authorities have a responsibility to protect those under its care. Having made those points, from page 7 to 8, the court returned to the facts in more detail before expressing its conclusion on whether an Article 2 operational duty of relevant scope was owed. And so once again, the focus is upon the scope of the duty and protection from harms for which the particular state agency has responsibility. And we see this also, I don't take my lords and my lady to it, in a case called Dove, where it was held that a state benefits agency doesn't owe an Article 2 operational duty to protect against risks of suicide, although it's well established that states benefits agencies do owe a duty to protect against the risk of death through destitution and starvation. Finally, in relation to substantive duties, let me turn to conditions for breach of the Article 2 operational duty. In most cases where the duty's been recognised, it's been framed in the way set out in the Osmond case. A duty on the public authority to take reasonable steps within its powers to avert a real and immediate risk to death to the person which the agency knew or ought to have known. A real risk being one that's substantial rather than remote, and an immediate risk being one that is present and continuing. That's paragraphs 38 to 39 of Ray Bain. That threshold has repeatedly been described as a high one, not because that adds a requirement of exceptionality, but simply because an appreciable real and immediate risk of death is harder to establish than merely a reasonably foreseeable risk of harm. But an important feature of the duty is that hindsight must be rigorously excluded when applying it, and therefore it is necessary to identify a point in time and say that at that point in time the public authority knew or ought to have known that the person was at a real and immediate risk of death and subsequently failed to take reasonable measures which would have had a real prospect of avoiding that risk. That is particularly stressed in the Van Col case. Now I show you one passage from that case, which is in the second volume of Authorities, Divider 44. Two cases concerning police protection. The first, an appeal on a Human Rights Act damages claim for breach of the Article 2 operational duty, held that the threat reported had not given rise to a foreseeable real and immediate risk of death. And Lord Bingham dealt with the correct approach from paragraph 29 on page 1345. And the passage I wanted to show my lords and my lady was paragraph 32 on page 1346. In its formulation of the real and immediate risk test, the Strasbourg Court, in paragraph 116 of the Osmond judgment, laid emphasis on what the authorities knew or would have known at the time. This is a crucial part of the test, since whereas here a tragic killing has occurred, it is all too easy to interpret the events preceded it in the light of that knowledge and not as they appeared at the time. I should just add that if my lords and my lady were to read on to the end of this paragraph, Lord Bingham says that public authorities are effectively fixed with knowledge of what they might have discovered through inquiries. That is a view with which Lord Phillips disagreed at paragraph 86. The disagreement has not, to our knowledge, been resolved. Mr. Justice Silber preferred Lord Bingham, in a case called Medihani. Mr. Justice Ouseley preferred Lord Phillips in a case called Griffiths. I don't think my lords and my lady will have to resolve the issue in this case. That's what I propose to say about general legal principle before turning to some brief submissions on the three grounds, unless my lords and my lady would like to pick me up on anything I've touched on so far.
No, thank you very much.
So our submissions on the grounds are limited to making observations on the legal analysis and the framing of the issues, rather than to say that the appellant's arguments are invalid. The first ground concerns whether the trust owed an Article 2 operational duty of the relevant kind and scope. Now, as I said, our submission is that the issue is whether the trust owed an Article 2 operational duty to protect a person in the position of Tanya Morahan from death through the use of recreational drugs, including in the community, so on leave. As my lords are aware, Lord Justice Popplewell held there to be no duty, and the rest of the court agreed with him, both on the basis that there was not a foreseeable real and immediate risk of death at the relevant times, and also by reference to the three indicia in Ray Bone, paragraphs 124 to 131 of the Divisional Court judgment. We would make the following observations on the appellant's arguments in this regard. First, in relation to assumption of responsibility, the appellant argues that what is important is the power of the trust to detain Tanya Morahan, not whether it had been exercised. We fully acknowledge that the decisions in Ray Bone and Fernandez de Oliveira decided that Article 2 duties existed to protect the voluntary patients against risks of suicide, and that the power to exercise control was an important factor. But as we read it, the Divisional Court's reasoning in this regard was that the trust had assumed responsibility to treat Tanya Morahan's paranoid schizophrenia, and that did not give rise to a duty to protect her from the harmful consequences of using drugs while on leave. Their focus, as we read it, was on the scope of the duty. The Rabone and Fernandez de Oliveira cases limited their conclusions to duties to protect against the risk of suicide. I showed my lord and my lady that in Ray Bone. In Fernandez, it's paragraph 124, Authorities 3, Divider 50, page 1599. Now, the issue for this court is whether the assumption of responsibility found to protect patients against the risks of suicide extends by analogy to protection against use of illicit drugs in the community. And Mr. Byrne submitted that a death due to drugs such as cocaine or heroin must be treated in the same way as suicide, because it is impossible to say at the start of a death investigation whether or not the death was in fact a death by suicide. With great respect, we wouldn't agree with that analysis. There are cases, certainly, where death due to use of drugs such as cocaine and heroin was possibly or probably a suicide, based on the surrounding circumstances. But surely it can't be said that that is always or presumptively the case. The present case is a reasonable example. There's no evidence or even any suggestion before the coroner that Tanya Morahan had any suicidal intent. There was no history of suicide attempts. All the references in the clinical notes referred to no appreciable suicide risk. And indeed, the evidence about loss of tolerance, which my friend has placed so much emphasis, only goes to support the proposition of a tragic accident. Next, in relation to vulnerability, the appellant argues that aspects of Tanya Morahan's mental health made her particularly at risk of using illicit drugs and suffering harm from such use. Now, Lord Justice Popplewell accepted, as did the coroner, that Tanya Morahan was vulnerable as a result of her mental health condition, which was itself exacerbated by substance misuse. But he reasoned that that vulnerability gave rise to a duty to protect her from the consequences of the mental health condition rather than from substance misuse. It is certainly true that the cases where the person's vulnerability has been found relevant have been cases where the vulnerability was directly related to the risk of death from which the public authority owed a duty to protect. And I showed the cases in which that point was made. It was also made in Fernandez de Oliveira, paragraph 124. You saw that where the court said, due to the patient's mental condition, his or her capacity to take a rational decision when his or her life may be to some degree impaired. Questions raised by the appellant's arguments appear to us to be, first of all, whether that is a relevant point of distinction, as Lord Justice Popplewell and the Divisional Court found it to be, whether Tanya Morahan's condition also put her at a heightened risk of death due to drug misuse, and whether that is sufficient to recognise an operational duty on the clinicians of the trust to avert that risk. Thirdly, in relation to the type and degree of risk, the appellant argues that the risk of harm from the use of illicit drugs was sufficiently acute or exceptional to justify the imposition of the duty. And the key issue here appears to be whether the risk was one which in essence was common to the risks faced by other users of such drugs. Our submission is that in relation, our observation is in relation to the submission of an Article 2 operational duty, I'll start again. What we address here is the submission that an Article 2 operational duty to protect against illicit drug use has been recognised on this basis in other contexts. Now, Mr. Bowen referred in oral argument to two Strasbourg cases, and I'll address those briefly as the last two cases I'm going to address. He also, in his skeleton, addresses three domestic cases, which we cover in a footnote on page 20 of our skeleton, the supplementary skeleton. I don't take my lords and my lady to those, because Mr. Bowen very fairly yesterday said that they didn't advance the argument. The first of the Strasbourg cases, these are both in Authorities Bundle 3, is the case of Marrow. This is divider 58 of the Authorities Bundle. This was an admissibility decision where a man had died in prison after overdose of an opiate, probably heroin, and the complaint of a violation of Article 2 was found inadmissible. My lords have been shown the relevant part from page 1958, the court's assessment. After summarising the operational and general duties between paragraphs 40 and 42, the relevant passage on which Mr. Bowen focused is at paragraph 43. The court observes that the applicants did not allege that the authorities had had any indication that their relative might be in a particularly dangerous situation, and that by taking drugs he'd incurred a potentially higher risk of suffering fatal consequences than other drug-taking prisoners. Therefore considers that the incident case did not concern the requirement of personal protection for one or more individuals identifiable in advance as the potential target of a lethal act, but rather the obligation to provide general protection for a vulnerable group of individuals, that is to say, drug-addicted prisoners. Mr. Bowen's submission is that one can infer from the use of the word therefore in the second sentence that there is a duty, that the court was recognising a duty to protect a prisoner against drug use if the prison authorities were aware that the particular prisoner was at a higher risk than other drug-taking prisoners. We would respectfully question whether that inference can necessarily be drawn paragraph 43 may equally well be read, we would suggest, as saying that on any view there is no question of an operational duty being in play. Then over the page on page 1960, the passages I asked to be pointed out. The court dealt with the duties which the authorities did owe, which were general duties to prevent drugs getting into and circulating around prisons, which was the focus of the admissibility decision, where the court considered that the state's procedures and arrangements were perfectly adequate. The final case is Zava, which is at divider 48 of the same bundle. There, a man with an asthmatic condition had died while in prison in Russia, and the official explanation was that his death was due to methadone toxicity. A violation of Article 2 was found, but that was on the basis that the official explanation of the death was highly suspicious. So that the state had failed to account for the death of a prisoner who'd entered prison in good health and fairly suddenly and suspiciously died. Turn to page 1521, page 55. We were shown this yesterday, referred to persons in custody being in a vulnerable position, and the authorities being under a duty to protect them. Consequently, when an individual is taken to police custody in good health, is found to be injured on release, it's incumbent on the state to provide a plausible explanation of how those injuries were caused. So, pretty much exactly the wording we saw in Salman earlier. Now, paragraph 57, we were shown parts at the start and at the end. In the middle of that paragraph, what the court found were a series of inconsistencies in the medical report and oddities, including the lack of prior reports of drug use by this prisoner, and the fact that the supposed needle sites were highly suspicious. They weren't where one would expect needle sites. So on that basis, the court concludes that the explanation provided by the Russian government for the death of Mr. Togonidze is not satisfactory and not convincing. Again, we're not sure that that establishes a more general proposition about obligations to protect against voluntary drug use which accidentally results in death. Turning to ground 2, whether the Article 2 obligation was automatically engaged, or Justice Popplewell's reasoning from paragraph 136 to 138 was that Tanya Morahan's death was in a category materially different from those in which the procedural obligation had been held to be engaged automatically, and that it would be wrong to say that the obligation was automatically engaged in the relevant category, namely deaths from substance misuse by voluntary mental patients, including when in the community. His reasoning was that that sort of death may take place without any arguable breach of Article 2 substantive duties, so that no inference of arguable breach could be drawn. Now, as I've already submitted, the question whether the procedural obligation is engaged automatically has to be a category exercise. Deaths by suicide and through attacks on prisoners are categories where the obligation is automatically engaged. The question here is whether the court should recognise a new category, and we suggest it would have to be deaths from substance misuse by voluntary mental patients, including when in the community. One consideration which the authorities appear to recognise as being relevant is whether the fact of any death in the category raises a natural inference that Article 2 substantive duties have been breached. Now, as we understood it, the submission that Mr. Byrne made was that the Article 2 duty of enhanced investigation is automatically engaged in all deaths of detainees, including voluntary mental patients. There was a suggestion this morning that there might be an exception for deaths by natural causes or apparent natural causes. Certainly, a number of the submissions yesterday, based on the reading of the Strasbourg authorities, referred to all deaths of detainees. Now, my lords and my lady already have my submission about the effect of the Strasbourg cases. We don't make submissions about the particular circumstances in this case. But we do say that the submissions would have some fairly striking consequences. For example, what if Tanya Morahan was on permitted home leave and died after being run down by a car driven negligently? Would that give rise to automatic engagement of the procedural obligation? It's a death through injury of a detainee, but difficult to see why the purposes of the convention would be furthered by the procedural obligation being required in that case. Secondly, we find it difficult to see how the reasoning in Tyrrell can stand with the submissions. Mr. Byrne raised 2 points of distinction. First of all, he said natural causes deaths are different, and we quite accept that Tyrrell was limited to natural causes deaths. But by distinguishing natural causes deaths, that does rather undermine the general submission based on the Strasbourg authorities that all deaths of detainees raise this presumption of law, which gives rise to automatic engagement.
Is it right to say that appreciate we've seen many authorities, and I understand Mr. Byrne's submission to be that one can deduce from them or infer from the language that the conclusion is the enhanced investigative duty applies in the case of all detainees, and then by analogy an involuntary patient who's actually at home. I understand his submission. But am I right in thinking that the Strasbourg court has never actually said that in terms?
I think my own friend referred you, I think, to a passage in Makaradze which referred to deaths of detainees.
Yes.
But of course, the circumstances of Makaradze included a very sudden deterioration, and in the other passage which I showed my lords and my lady, there is some emphasis placed on that.
Yes.
On that aspect.
So my reason in asking is whether we are, in this context, in Allah territory, as explained recently in AB, in the Supreme Court.
Yes. Lords and my lady may find yourselves in that position. There's a helpful discussion of that in the recent Gardner case in the Divisional Court. For Justice Bean, Mr. Justice Garnham. For my lords and my ladies, note that supplementary authority is divider 4, page 13, at page 74, from paragraph 250. Page 74. This, of course, was the case concerning whether an Article 2 operational duty was owed to residents of care homes to protect them from risks of death arising in the COVID-19 pandemic. The court summarised the principles from the domestic and Strasbourg cases at paragraph 250, citing, among other cases, the judgment of the Divisional Court in this case. And then from 251, they cited from the well-known passages in A.B. my lord no doubt had in mind.
Yes.
Before saying at 252 that to find the duties for which the claimants were contending in that case would involve running past Strasbourg jurisprudence and disappearing into the distance. That's the penultimate sentence of 252.
Yes, so they applied the conclusions that Lord Reed articulated in AB at Paris 54 and surrounding. Yes.
The other point of distinction Mr. Byrne raised in relation to Tyrrell was that the state had accounted for the death and so discharged the Article 2 duty before the stage at which my lord said that it wasn't present. In our submission, if Article 2 is engaged, then subject to procedures other than the inquest, the investigation has to be carried through to its conclusion and must satisfy the Middleton requirements. It's difficult to imagine the Article 2 obligation arising and then dissipating through the mere provision of evidence to the coroner in a forum which, of course, wouldn't satisfy requirements of transparency and involvement of the family and so on. And I finally turn to ground 3, which is whether the Article 2 procedural obligation was engaged on the basis of arguable breach of the operational duty. That issue arises if a duty arose, which is the duty raised by ground 1, and the reasoning of the divisional court was that over the material time, there wasn't a point in time where the trust arguably ought to have foreseen a real and immediate risk of Tanya Morahan dying from drug use and taken measures which would have had a real prospect of saving her life. That's para 134. Now, the appellant is right to say that the question at this stage was whether, assuming a duty existed, there was an arguable case on the evidence that an Article 2 duty was breached in relation to the death. The arguable case threshold now has a substantial pedigree in the authorities, including the passages in Humberstone which I showed the court. It is a low threshold, consistent with the early stage in which it's applied, as Lord Justice Popplewell specifically acknowledged at paragraph 75 of the Divisional Court judgment. But as he said there, it has to be applied based on the available material and without speculation, as well as with a careful exclusion of hindsight. I've made those points good by reference to Humberstone and Van Col. In our submission, the threshold of an arguable case has been the subject of enough glosses without adding the compounding factor of an analogy with the serious issue test in the American cyanamide line of cases. To do so would only bring in a further corpus of authority to be considered, including a number of cases which have themselves glossed American cyanamide as to the precise degree of merits consideration which is required. The appellant sought to make an arguable case of breach on 3 grounds concerned with steps taken before the first absence and care planning generally, secondly after the first absence, and then finally after the second absence. In our submission, applying the test properly, avoiding hindsight, requires my lords and my lady to consider the position at each point in time and ask, first of all, at that point in time, should the trust clinicians have foreseen a real and immediate risk of Tanya Morahan dying through drug misuse? Secondly, should they as a result have taken further steps within their powers, then or later in the chronology, to avert that risk? And thirdly, would those steps have had a real prospect of saving her life? Not whether they would probably have done so, but whether they would have had a real prospect of doing so. And that, of course, is applied on an arguable basis. So first, addressing the position before the first absence and care planning generally, the question is whether it's arguable, having regard to her period of abstinence from drugs, that clinicians first of all should have foreseen a real and immediate risk of death from drug use in the community. Secondly, before that first absence, taken further specific practical steps to prevent that, and then that those steps would have had a real prospect of saving her life if implemented. Now, we respectfully agree with Mr. Byrne that planning for aftercare under section 117, planning, begins from the time of admission, and that such planning is important. But one needs to ask whether it is arguable that proper planning would have resulted in the trusts taking specific and practical steps which could have saved Tanya Morahan's life. Mr. Byrne referred to Baroness Hale's judgment in Ray Byrne at para 107. All we would say about that is that her ladyship's approach, unsurprisingly, was rigorously practical. Secondly, addressing the position after the first absence, the question here is whether it is arguable that Dr. Rahim and her colleagues ought to have foreseen a real and immediate risk of death from drug use and taken action which would have prevented Tanya Morahan leaving the ward, that is to say, detention or an effective refusal of leave, in the sense that it would have prevented her leaving. Now, the court will no doubt bear in mind the explanation given by Dr. Rahim while subjecting it to proper scrutiny. I won't say any more than that on that point. Thirdly and finally, addressing the position after the second absence, is it arguable that the clinicians should by that stage have foreseen a real and immediate risk of death to Tanya Morahan through drug misuse? And if so, is it arguable that they failed to take some step within their powers, which first of all they should have taken, and secondly would have had a realistic prospect of saving her life, such that she lost a material and substantial chance of survival, focusing, as I say, upon what the trust clinicians should have done, because the case being made is not in relation to the police. So, my lords and my lady, that's what we say in relation to the grounds, I hope preserving the position of assisting the court, which was adopted throughout. Are there any other points on which my lords and my lady would welcome assistance, including on the fresh evidence application?
No, thank you very much indeed, Mr. Hoff. Now, Mr. Bowen.
Just switching my microphone back on, my lord. I see the time. With the best will in the world, I won't finish in 8 minutes. And I wonder whether my lords would prefer to rise now, and perhaps start just before 2 o'clock, or whether you'd like me to crack on.
How long do you think you're likely to be, Mr. Bowen?
Maybe 20 minutes.
Well, I think it would be convenient to start, and you've got 7 minutes. No doubt you can deal with one of the discrete topics in that time, and then we'll resume briefly at 2 o'clock.
Of course. Well, what I'll do, I'll just deal with my own friend's submissions as they were made. He made a number of points on the facts, and I just note that he referred to the opioid test as having been something that the divisional court was aware of. You'll recall I took you to the entry in the A&E notes of the 3rd of December. I took you to those in order to demonstrate that the divisional court's conclusion that there was no history of accidental overdose was arguably incorrect, because there is no reference in the judgment to that entry, the fact that she had to be admitted to A&E for several hours while she received fluids, and while her heart rate was monitored and brought down. My letter friend's submission was, that's not an overdose. Well, my lord, if being admitted to A&E and having fluids administered for several hours before one can be discharged does not account as an overdose, then short of actually dying, I'm not quite sure would amount to an overdose, and I'm not quite sure what my learned friend is referring to, whether there's some kind of expert evidence or some ex machina interpretation of overdose that he's relying upon. I would simply say that as a matter of common sense, when someone's admitted to hospital for several hours and received treatment like Tanya Morahan did, that amounts to an overdose, and that the division court was wrong to suggest otherwise. He took you through the multidisciplinary team minutes that I showed you, and he pointed out, for example, one of the issues, one of the matters that were relied upon by the multidisciplinary team in deciding that Tanya could be discharged on the 25th of June was that there had been no issues with drugs or alcohol. And you will recall there's a specific reference to the fact she'd had a number of alcohol and drug tests that had been negative. Well, when one asks the question, what changed between the 25th of June and the 1st of July, when she went AWOL, as the divisional court does rhetorically at paragraph 131, well, one thing that had changed was that having had 6 months where she was abstinent from alcohol, the very first time she was allowed out on leave, she went AWOL and got drunk. Indeed, she travelled to Germany. So there was obviously a significant change. And we come back to the point that that was clearly a matter that would need to have been addressed. We submit within the multidisciplinary team. We emphasise the fact again there was no record in the minutes of the team having discussed what change there had been and whether it justified revoking her leave. We drew attention to something which Mr. Hoff did not mention, which is that in the multidisciplinary team meetings, it is stated in bold that if she were to go AWOL, her leave would be revoked, but nowhere would you find any record of the team having actually considered that issue. All you have is an ex post facto statement from the responsible clinician without any contemporaneous evidence. And that is precisely the sort of evidence which it is very dangerous to rely upon in situations such as this, and this is why it's necessary to have investigations of the kind that Article 2 requires. My Lord, it was suggested by my own friend that I've made this submission that Mr. Owen had submitted that there should have been another sort of risk appreciated because of her prolonged absence by the doctors, namely the risk that she would overdose if she were to relapse into drug misuse. And I just point out Mr. Hoff's submission on that was that he doesn't disagree. That was his submission. And we emphasise that is the most important of the risks that were not taken into account. There is no reference in any of the evidence, even in Dr. Rahim's witness statement, to the psychiatrist and the rest of the clinical team having considered what might happen if she did relapse into cocaine and opioid misuse. And given the degree of risk that they themselves assessed her as being likely to relapse into drugs misuse, she was at high risk. It was frankly extraordinary that the psychiatrists did not address that risk as part of the risk assessment that should have happened at least at the point that she'd gone AWOL for the first time. My Lord, that's what I have to say about the evidence, and that might be a useful point to adjourn, and then I can deal with the legal submission that my learned friend made after lunch.
Certainly, we'll look forward to that. We'll adjourn now till 2 o'clock.